contract employee, or, you know, and they try and create these hybrids and stuff. Well, the next thing I know, I'm on the agenda to talk about a different employee. And as I thought about this more this afternoon as I'm reviewing my notes and stuff, we're really not talking about so much different types of employees, because most employees, I mean, they're going to fall into a few different categories. Employees are either full-time, part-time, seasonal, great workers, just there to collect their paycheck, or totally useless, right? I mean, that's about the categories. So we're not really talking about different types of employees here this last half hour of the day. We're talking about the different employer responsibilities that you have to different types of people. Because people that aren't really your employees, you didn't hire them, sometimes you have employer responsibilities to them. And so that's the type of people, the different types of people we're going to talk about here to run out today. So who am I talking about? And what are the different types of employees that we have out there, that we have employer relationship with? Certainly our at-will employees, and we'll talk about what that means. We have employees with contracts. We have elected officials, elected and appointed officials. We're going to use the example of constable to talk about appointed officials. We've got volunteers that we all know we have certain responsibilities to as an employer, even though they're a volunteer. Explore that a little bit. We have interns, which are kind of quasi-volunteers, but not really, so let's talk about that. We have compensatory service workers, which are our boys in orange from out of the jail that we need to deal with. And then we have true independent contractors. And we'll talk about what really is an independent contractor versus your employee. Okay, fair enough? Let's get at it. So the different issues that we have to deal with is, with all of these different people, is what compensation might we owe to them? What benefits do we owe to them? We heard about a new one today, surviving spouse of a fallen officer, right? Now all of a sudden we have benefit, employment responsibility to that person whom we never hired. Do we do performance evaluation or not of these different types of people? Can we discipline, or do we have to discipline these different types of people? Can we, or should we, or may we terminate? How do we end that relationship with these different people? And then most importantly, how do we manage the risks associated with all these responsibilities with those different types of people? So is this looking like something that we need to talk about today? I was hoping that it would be. At-will employees. Now most of us consider the majority of our employees at-will employees, right? Because USIP's been recommending that's a best practice, right? And our employment attorneys do. And even our employment attorneys will tell you that in most cases, when we get to court, the judge is going to find, no, they're a government employee, and because they're a government employee, they have a property right to their employment. But starting at they're an at-will employee, we tell them that when we hire them, we tell them that all the way through their employment, and so we don't need a reason, we don't need good cause to terminate them, we can just let them go when we want to. It's a good place to start for our defense. And once the judge says, no, you've got to have a reason, okay, well, it's kind of lowered the bar as to what the reason needs to be to terminate them. So it still helps in the defense to take that position of that they are an at-will employee. Okay. So they can leave anytime they want for any reason, and we can let them go anytime we want. Without it is the idea of at-will employment. And of course, many of you know, especially the HR professionals, though, that's a tricky fence to walk, because lots of different things that you might do in your employee manual, in your employee staff meetings, in conversations between their supervisor and them during performance appraisals and things, can all of a sudden create a contractual, non-at-will relationship with them. So maintain that at-will position as an employer is in and of itself a whole presentation that will lead to one of our attorneys at some point.
And state law would require you to be non-at-will.
Yeah.
Yes. So again, for those who you are trying to maintain an at-will relationship, just watch the language in your personnel policies, handbook, correspondence, those sorts of things. But again, from a defense standpoint, that's the preferred status of employees. The next type are your employees, but for some reason you have a contract with them. I see this happen very often when you've got an option for people to retire early, or for some a URS type opening where, okay, I'm retiring because URS has an opening for me where I can buy my final year's cheap or something like that. And so SIGA and the county says, we really need you to stay. We need you for just one more year. So there's a special relationship all of a sudden. It's not just an at-will relationship. So you might enter into a contract with that employee to keep them for that additional year or so. And they can still retain that option to be able to use the URS retirement. So that's one way. I've also seen counties where they may have a semi-professional position that they're trying to hire, that they cannot find a person in their small rural county that's a semi-professional that will work for the wage that their merit system allows for, right? So how do they get around it? To the merit system, they enter into a contract with that person to take them out of the merit system. It's their strategy to be able to pay the higher wage that semi-professional position requires to be able to find somebody to work in that position. I'm not sure the legality of that, but that's one of the ways that I've seen, one of the reasons for contracts that I've seen counties use them. So again, there may be situations where you want to do this, and you want to be careful, though, not to confuse employees with contracts with independent contractors. Those are two different things. We'll talk about independent contractors later. This, for the most part, you're going to have their employment status is going to be the same as every other employee, with the exception of that, you're asking them to stay a year. You're not going to terminate them within that year. You're going to only terminate them within that year for good cause shown, or something like that. With that one exception within the contract, they still have to comply with all the other things in the personnel manual. They still get the same benefits. You want to retain as much of the regular employment status as possible, because you don't want to create a disparate treatment situation either. So be careful of how much you meddle with that position. Corey?
Question. You have the at-will employees here. What category does a career service or a merit employee fall under?
Well, most counties, their personnel policy still says all employees of the county are at will. So even though they're career service or merit, they're still considered generally an at will employee. So I think, again, this type of a situation should end up being used on a pretty limited basis. When they're providing professional or semi-professional, it's mandated by state or federal law. They're working under a grant, something like that. I mean, that's the other reason that I've seen counties use an employment contract, that we're going to employ you, but if the money from the grant that we're paying you out of dries up, we're going to have to let you go, kind of thing. So they use a contract to do that. I don't know that you need to do that, but counties are using that. Okay, so that's a different type of employer relationship. Then we have elected and appointed officials. Now, pay them, so we've got compensation, right? We've got benefits going to them. But when we get to some of those other areas, like how many of you perform a performance appraisal of your commissioners? How many would like to do it? When you do, every 4 years, right, they get a performance appraisal. That's the way it works. Can you discipline them? Can you terminate them? You can terminate them, but it's a rigorous process that the county attorney needs to go through in order to expel an elected official or elected official from office. Appointed officials, again, depending on how you've appointed them and how you've structured that position, you may or may not be able to terminate them. Okay, so I'd recommend you go back and take a look at all the appointed officials that you have within the county. Take a look specifically at, you mentioned that the employee handbook and employee rules in that appointment, that they are to comply with all the employee manual requirements. Do you spell out for what reasons they can be expelled from their appointment or their appointment may be terminated? Don't I look at that. Give yourself as much latitude there as you possibly can. Again, if you set out the written policy and duties and limitations on those officials that you're appointing, it's going to save you a lot of headache down the road. Okay? As an example of an appointed office, constables, which is a really different animal, because this is one where the county can appoint if they want to, but they're a little bit different once they're an appointed official, because statute says how you handle them rather than you determining how you're going to handle an appointed official. Because you appoint planning and zoning commissioners, you appoint people to all different types of county committees, commissions, and things like that that you're not mandated to have, but it just makes good sense to have them. So you appoint those people to positions. Constables, however, and this has become, again, about every 5 years or so, they rear their ugly head and they become an issue for us. And it's happening again in several counties. So I just wanted to go over this as an example. It's very difficult for a county to control constables from a risk management standpoint because, again, the statute has set out their duties and responsibilities. So you don't have a whole lot of control on what their duties and responsibilities are going to be, other than then you can limit them to only the things that are in the statute, that they're statutorily prescribed to do. Statute provides for a 4-year term once they're appointed, and the constable's appointment can only be withdrawn for cause. Clearly not any type of at will. Once you've appointed a constable, you've got to give a reason, a good reason, to not reappoint them or to withdraw or terminate their appointment. Again, their authority is laid out in statute, which limits the county's ability to restrict those activities. And there have been several circumstances. We've had a lot of close call claims filed where the constables have used their office to do a lot of things that are not contemplated in the statutes. They're running auctions, and they're selling vehicles in auction type situations, and just doing some really odd things that aren't intended under the statute, but they've got a uniform and they're going to use it. So where is your ability to do some risk management with these? And it really starts right from the decision of whether or not you're going to have a constable within your county. Because the first step under Title 17, Chapter 25A, that spells out the constables, is that the governing body of the county decides whether or not they're even going to have an office of constable. And the statute reads that a county or city of the first class may have an office of the constable. And there's an argument in one county right now, a person that wants to be considered to be a constable, and the county attorney over does a county or city of the first or second class mean any county or a city or a city of the first or second class, or does it mean any first or second class county or any first or second class city? The statute's not clear. So there's a lot of pressure on this county that is not a first or second class county to have an office of the constable, and the county attorney is just saying, we can't. Statute doesn't allow for it. We're not a first or second class county. We can contract with Salt Lake's constable, or Salt Lake City's constable, or Washington, or St. George's constable, but we can't have our own. That's their county attorney's position. Other county attorneys may have a differing view and say, no, any county can have an office of the constable. But that is still the governing body's decision. Are we going to have an office of the constable or not? If they decide that they are, then the statute lays out a nominating committee, which is a commissioner, the sheriff, I think one police chief. I mean, it prescribes exactly who sits on that nominating committee. So again, you can't just throw one together. You've got to have the people that it identifies in the statute. And they will review applications for appointment of constables. So one person doesn't just go in and be appointed as constable. They've got to go through this process of going to the nominating committee to show that they meet the requirements. And then the nominating committee recommends applicants that are most qualified for appointment by the governing body. Then the legislative body must either appoint or reject each one of the nominees. So they might get 2 or 3 nominees from the nominating committee, and they have to either accept or reject each one of those 3 that were nominated. Then once they've appointed a constable, that constable can appoint deputies, which the county is then responsible for, because you're responsible for that constable and his actions as if he's your employee, and all of his deputies as if they're your employees.
Again, I'm not very intelligent on this stuff, and neither is Joe, because I asked him if he didn't know we had a constable. Is that a person? I mean, to me it sounds like a law enforcement officer for you, but exactly. Oh, Bobby. Is that somebody who is like your civil deputy that goes out and serves papers, or could it be a court bailiff?
Yes. Well, their duties require them to attend the court, the local court, if need be. So if the judge wants the constable there, he has to make himself available for each court hearing if the judge says that he wants him there. That, I think, is in addition to the bailiff.
Okay. So it's basically somebody that you hire to go out and serve papers.
Yes. So they would serve your warrants.
Right.
And they also serve process for private law firms. That's why they want to be constables. And so they come to the county and they say, hey, you've got a bunch of outstanding warrants that I'll go and serve, and you'll collect that money, so I'm going to make some money for the county. And they get paid for each one that they serve. But they also then go to the private law firms and say, I'll serve process for you, and you pay me. And the statute prescribes what they get paid for that. But then they dream up, like I say, these other things that they do that sometimes get them in trouble.
So if it's a full-time deputy that we have doing that process, can they also do the private practice?
Yeah, that's just it. You don't need to, because I've discussed this at the Sheriff's Association meeting, you don't need to use a constable to do that. You can use your own deputy to serve warrants.
But you could hire a constable service, if there are companies out there that do that. You could hire them instead of having your deputies that if you wanted to.
Well, yeah, the law firms can hire private eyes, you know, there's other ways for them to get their process, their papers served. Serving the warrants is a little bit more, again, you can contract with a constable in another county, and then you don't have to worry about this employment relationship with this guy. That's another county section, or another city. Find a first class or second class city that has an officer or constable, contract with them. And the statute lays out what you're going to pay them for serving your warrants, and you're done.
So we have constables, and I guess my question is it fair for us when we appoint a constable for them to have somewhere in their contract or agreement that they have to disclose what else they're doing or running through their office?
Well, that's the difficult part, because you don't have a contract or agreement with them. You're appointing them as an officer.
Right. So we don't, I mean, you're saying a lot of times people don't know, but if we can't ask and find out, then of course we don't know. So that's my question. Is there a way to find that out legally and have them have to disclose things like that? So if there becomes a conflict of interest or something, then we could look at that and know better in 4 years, or, I mean, I think that there's things where, you know, they don't have to be 4 years, but.
You can ask, I don't know that you can enforce it, because they're going to say, again, you wouldn't have a contract with them.
That's true. I guess you just tell them if you do something wrong, we'll be serving papers to you.
I would make sure that they are given ethics training, number one, so that they understand what they can't be doing, that there are felonies under the ethics code for government employees and officials, so that they understand that. Yeah, this is one of the frustrations, again, at the Sheriff's Association. Every couple of years they need to do something with this statute. A couple of years ago they went in and they said, you know, they have to wear a uniform. It has to identify them as a constable. But it doesn't, it's not going to say Fox Elder County constable. It's just going to, or sheriffs. Because what was happening a lot of times was they were wearing a look-alike sheriff's uniform. Like they were the sheriff's constable. Well, no, this is a separate office from the sheriff's, which is another area of hard work for the sheriff. This person has to be a special function officer, certified by post as special function officer. It's quasi law enforcement duties. They like to push it to more law enforcement duties, and so the sheriffs are real concerned about these guys out there. There's good ones, but there's been a history of some bad ones too. So they really question the need for this going forward.
I was just going to say, they're SFO post-certified, but that's very minimal training. They don't even get basic corrections. They're just an SFO.
Yeah.
But they can still tell people, well, I'm post-certified.
Yes. They're not lying.
No, and they're
telling
not
the whole
lying.
truth, but they're not lying.
Yeah.
So again, that's a good example of an appointed official that, boy, that's kind of way out there. Very limited ability for you to manage their risk. So again, because it's been an issue lately for a couple of the sheriffs being pushed. What's happened is people have come and said, Sheriff, I want you to deputize me as the constable. That's not the process. And so watch out for that. People's coming, or if they're coming to your county commission and saying, will you appoint me as your constable? Some county commissions aren't aware of the law, believe it or not. And then they'll say, well, why would we do that? Well, because we're going to serve all your warrants that are all sitting over. I'm told there's 100 warrants, outstanding warrants down in the sheriff's department that will serve, and you'll collect all that revenue. That sounds good. At the end of the year when the budget's running dry, right? So they think it's a no-lose proposition. They appoint a constable. Number one, now you have a pseudo-employee to deal with. And number two, they violated the statute by just simply appointing them without doing the nominating and all that. Okay? That's constable. Volunteers. How many have had to listen to Johnny's speech about volunteering? Almost all of them. Again, a different type of employee here in Utah. Anyone that volunteers service to a government agency in Utah is provided certain employment rights as an uncompensated person. So an uncompensated person providing service to a government agency must be authorized in accordance with the Volunteer Government Workers Act. And again, must be. The statute says no person shall provide a service to a government agency until they are authorized by that agency as a volunteer. They cannot just come and volunteer for you.
So I have a question. How do you enforce it? I just had my fair. I had no volunteers approved.
That's a performance issue for your
But it's your
fair
commissioners.
directors.
Problem. You
Fair
know?
commissioners.
Right on.
Right.
Well,
But you know what I mean? Our policy specifically says the commission has to sign an application that they fill out. And I just told them, said here, I said, well, they're not covered. Now,
right.
can I
So,
enforce that?
because the volunteers are the ones that really need to be concerned about that.
Right.
Because number one, they're violating the statute by even providing the service, for being there, in violation of the statute. Secondly, if they injure someone or damage somebody's property, they're on their own. The county is not obligated to defend them. They're not obligated to pay any judgment against them. They're not obligated to pay any injuries for them. So, you know, and again, this is one of those odd situations where I'm telling you, I want you to grab hold of these people, get them authorized, because if they're authorized under the statute and they do injure somebody or damage somebody's property, now, number one, they're dismissed from the case as an individual immediately, because you can't sue an individual employee of the county, right? And now they're an employee for purposes of liability. So they're out of the lawsuit. They're happy. You've got a volunteer that's going to come back next year and look at it. And number two, we've got all the immunities and court caps for that person's actions. We're going to end up with the lawsuit on a secondary basis as, well, you should have never let that person even be at the fair because they weren't an authorized volunteer. So we're going to sue them individually and take everything they own. And we're going to sue the county for wrongful detention, wrongful supervision, and all you know, everything else that they can do. So we're going to have a claim anyway. Easier for us to handle the claim. They're a nice, clean, authorized volunteer.
Okay, so remember we're new. So how do you authorize a volunteer?
Well, that's a little different because you're a special service district.
Yeah, and not only that, how do I have to authorize my 70 volunteer soccer coaches this fall?
You know,
That's a, yeah, I heard, yeah.
I would do it. I just have a process in policy at the district that volunteers are going to apply for positions. They're going to be approved
We're going
by.
to beg them.
We don't apply, we beg.
Well, you beg, but you still, you get their name, you get their cell phone number, right? I mean, that's your application. I mean, don't ask for their insurance information, don't ask for
Just their name and whatever.
Yeah, just basic information, and
That's all you
then
need?
They're gonna be approved by whoever is the personnel director of the district.
Don't we technically have that because we're online registration where we have that parent's information?
Their name and contact information.
You can use that as the application. They go online and say, I want to volunteer, you can use that as the, that's the way Salt Lake County does it. You go online to look at volunteerism in Salt Lake County, and what they use to sign up to say, I want to volunteer, is their application. And that application goes to
Disclaimers
HR.
on that, the application at all, is there any type of disclaimers on there? Like, we were told a long time ago that we needed to put on there that they would be cited by workman's comp, if it's for medical purposes.
Yeah, the counties that have asked me to look at their applications, that's what I have to put on there. That under this code, you are going to be covered. If you injure someone or damage someone's property, the county will treat you as if you're an employee. They will provide a defense to the county attorney's office. obtain any judgment against you, then you will also have the immunities. And if you're injured, you're going to receive workers' comp medical benefits only. So that they understand they don't get paid for lost time from their day job, they just get the medical benefits. And if they're, I also have them usually put in some language about if you use your own vehicle, your vehicle's insurance is first, county's vehicle, auto liability coverage would be excess over that type thing. Just to give them a real good feeling of that that's a much better situation than being a volunteer to any other organization in the state.
So do you have that form online so I can compare it to ours, or?
I can get it to them.
Okay.
Yeah.
I have a question about kind of transitioning that. So on our volunteers for the fair, for example, we're going to become an authorized volunteer, we do a soft background on them to make sure that they're not a registered sex offender. There's a lot of work in that that you do. Do you guys do a background check on your coaches?
Should you?
No.
Should you?
No,
Is
we
that
don't.
something you should consider?
No.
Johnny, what do you suggest? Like, do you think, are we going too far? Should we be doing that before we
That's for sure.
authorize
Best
them?
practice, absolutely, if they're working with children or vulnerable adults, you should look at doing that. Because again, you're going to get the negligent retention and negligent supervision thing if you don't.
Right. But not a drug screen, right? That we don't typically do, but we've actually been going back and forth on it. What would you recommend with
I
that?
would recommend you follow your policy, because most of the county policies that I have seen say that we will do drug testing of all employees and volunteers. But then the volunteers aren't getting tested. They're not even in the random list.
Can't even get them to sign
So
up.
follow your policy.
That
And
would
if
be
you're not
lucky.
going to So again, that's something that I have right on the application form is, oh, and by the way, as a volunteer who gets some employment rights,
You'll be set.
you'll be subject to the county's policies and procedures regarding employees, including the drug testing policy. Which again, does make it kind of tough to find volunteers, doesn't it?
But then it's hard too, if you're for drug.
Right. So that's a decision that you need to make, is depending on what type of volunteering they're doing. And certainly if they're doing volunteer service for their driving, other, yeah, working with you, that's another one. Again, maybe then you do need to include them within the drug testing policy. But if they're volunteering to tend the flowers outside of the courthouse,
Unless they're driving and smoking, then they're
So please, check your own policy, because if you don't have in your policy that you're going to do drug testing of volunteers, that's better than to say you are going to drug test volunteers and then not follow your policy. Judges are not tolerant of you not following your written policy. Not at all.
Thank you.
Okay. So we've got employees for workers' compensation, medical benefits, auto liability, and liability, the same as if they were an employee of the county, right? So they're immune from liability in accordance with the Immunity for Persons Performing Volunteer Service Act. So again, not only do they have the immunities because they're some, county employee to some extent, but there's a separate persons that are volunteers in the state of Utah are immune from lawsuit. So that's a good thing. Again, put that in there. And any agency that is assisting you in finding volunteers, as a volunteer facilitator, they are immune as well. So if you're trying to find people that are going to help you find volunteers, make sure that they're aware of that. You can't be sued for helping us find volunteers. Now, within that Governmental Volunteer Workers Act, there's also the Volunteer Safety Officer. Now, the Volunteer Safety Officer, law enforcement and firefighters, they also get all the benefits that other volunteers get, but they also get workers' compensation benefits for lost time. So if they have a day job that they're going to lose time because of the injury that they received volunteering for you, you're going to pay benefits based on the statewide average weekly wage. That's the way the statute is. It doesn't even matter what they earn at their day job. You're going to pay benefits based on your workers' comp carrier is going to pay based on the statewide average weekly wage. That will destroy your experience model. So be careful for that, because how do you return to work somebody who is volunteering for you and works for another employer, but your workers' comp carrier is going to pay benefits until they return to their job, full employment status, full earning capacity. So again, you can really wreak havoc for your benefits, for your costs. Okay. Then we also have the volunteer search and rescue people, who are very much like the last group that we just talked about. However, they're going to get lost time benefits, but it's going to be based not on the statewide average weekly wage. It's going to be based on the average starting salary of a deputy in your county. It's not statewide. Whatever the average wage for an entry-level deputy in your agency is, that's what their benefits are going to be. 33 and 2/3% of that amount. Okay, so it's a little bit better, but again, return to work is a real issue when you're talking about volunteers. Compensatory service worker is any volunteer or person performing public service for an agency as a condition of their incarceration, plea, sentence, diversion, probation, or parole. They are going to receive benefits under the Governmental Workers Act for purposes of workers' compensation for the medical benefits only, like other volunteers. But that's all they're supposed to get. They're not supposed to get any coverage for liability. So if they injure someone and damage somebody else's property while they're picking up garbage in the ditch, the law says you're not responsible. A statute. Case law, however, based on a Utah County case, is that you may be responsible to a third party who's injured by this person. Okay? So that, as you rethink what types of things are you having compensatory service workers do for the county. And I always get the question, we don't have a choice, the judge sentenced them. I don't know, I'd talk to your county attorney. The judge can have a sentence, but that doesn't mean you're out. You're not on trial. He can't obligate you to put that person to work, I don't think. So I've talked with several county attorneys that don't think so either. Or, you know, if the judge says, no, you are going to put that person to work, okay, they're the greeter at the door. Because we're not going to put them out in public where they can injure someone. And they have to pay that claim. So be cognizant of those people too. Interns, kind of the pseudo-volunteer. However, many counties accept them for different reasons. Generally because they attend a school that requires an internship as part of the curriculum, right? I mean, I did an internship when I was a law enforcement student, and it wasn't because the police department wanted me, it was because the school required so many hours of internship for me to graduate. It's to my benefit as a student and the school's benefit, and I know that most of those curriculum-based internships allow for observation internship only. That's the way it's written. The school is saying you're not to work for that person, and county, you're not to put them to work. They're there to observe. But how many of you put them to work? Okay, you get some. So I see two different types of interns. There's the intern that really is following the rules of a curriculum-based internship and just observing. Those guys, you know, you should leave the liability with the school. They're the ones getting the benefit on it. You're providing their place where their students can get their hours of internship and graduate. If you are soliciting interns because you want them to get some work done, then I think you need to accept some of that liability. You need to think about how you're going to control that. Certainly, if you compensate that intern in any way, they're not really an intern anymore anyway, right? They're an employee of some sort, and you've got to sort that out, part-time employee. But if they're not compensated, I would say treat them as a volunteer. Authorize them as a volunteer. Now you've got some coverages for them. You've got some liability protection, some workers' comp protection, and treat them that way. Okay. Joe talked about the spouses of fallen officers and another pseudo-employee type situation. And again, if you're not sure what you're going to do with the trust, at the very least, for those of you who purchase insurance from a health carrier, look at the definition of employee and go to that health carrier and talk about, will you amend your definition of employee to include a spouse of a fallen officer in accordance with the statute? Because if you don't have that, you can't do what the statute requires you to do. The insurance company won't recognize them as an employee. You can't buy coverage, no matter if you're willing to pay the price or not. Okay. Independent contractors. And again, these are the guys that people like to call them an independent contractor because then they think, oh, I don't have to pay URS, I don't have to pay merit, I don't have to, I can leave all the liability to them. But again, independent contractors, the courts look at tests of control. How much control do you have over that person to determine whether or not they actually are an independent contractor or an employee? Now, when do they apply that test? Is it at the time that you're thinking about having them provide service? It's after a lawsuit's filed, and they're trying to find a pocket, a deep pocket, to pay a claim, right? So, the things you want to think about is, when you think you have an independent contractor, ask yourself, can they and do they provide similar services to other people? Can they provide any other service to any other people? Do they advertise their services to others? Are they truly in the backhoe business, or are they just running backhoe for you and you only? Do they provide their own equipment? Do you provide them office space? Do you supervise and direct their work? To tell them in specifications, here's the project that we need done, and here's the outcomes that we want, is fine. But to go in on a daily basis and say, okay, next I need you to do that, and then when you're done with that, you need to do this piece, that type of control, they're no longer in the contract under that piece. And when the courts add up enough of these, they're going to say, they're your employee. Do you have a say in who they employ? That's another one that the courts look at very closely. Is their compensation set up with a win-lose potential? That's another big one. If you set up an agreement with an independent contractor where there's no way that they can lose money on the deal, they're your employee. They're not. They have to have some potential to lose in their relationship with you. Do they have their own insurance? And that, again, if they're purchasing insurance for what they're doing, then it's a better indication that they're truly in that line of business. And are they incorporated as a legal entity? I can't tell you how many people I've found that counties consider an independent contractor and they're not incorporated in any way, shape, or form. They're just an individual that the county doesn't want to hire as an employee, but they want their service, so they create an independent contract agreement that's never going to hold their water. Okay, so be really careful with those independent contractors. And again, a judge will look at these and a couple of other issues and weigh